Hi everybody, today I'm going to be talking to you about the court case Santa Fe Independent School District versus Doe in the year 2000. This lawsuit has to do with school prayer, specifically at football games. And in this case, most of these prayers were Baptist. They were in a rural school district between Houston and Galveston, Texas, and the prayer was being forced over the public broadcasting system at school football games during every home game, and the prayer was said by a student. The plaintiffs filed anonymously because they were afraid that their students would be harassed. This really angered a lot of school employees, and the school employees asked the parents of the students if they would be willing to sign a petition to make it so that they would know who the people suing were, because they wanted to either kick them out of school or know who was causing them these problems. These students were one Mormon and one Catholic, and their mothers that filed this lawsuit. So the case itself, again, was dealing with school prayer at football games, and the students and their mothers were suing, saying that it was unconstitutional due to the protection of the Establishment Clause. What the Establishment Clause is, it's in the First Amendment, saying that Congress cannot force religion on us. And this goes again with the Free Exercise Clause. So those two work together to make it so they cannot pass law forcing religion on us. So while this lawsuit was pending, the school district put in place a new policy to make it so the prayer wasn't forced. And so what it was they put two elections in place. The first election would be for whether or not prayers would be said at the football games, and the second was for who would say it. So it almost turned it into a popularity contest between students of who got to say the prayer and who didn't. The school district's defense was that it was private speech, that they weren't forcing it, and that the speech was private. It wasn't a public act of speech. But the court decided that the message of an invocation on school property at school-sponsored events over the school's public address system by a speaker representing the student body under the supervision of school faculty and pursuant to a school policy that explicitly and implicitly encouraged public prayer, it is not properly characterized as private speech. And this is what the Supreme Court found. It was a 6-4 Supreme Court decision, and a lot of the case was based off of a previous Supreme Court case of Lee versus Wiseman, which made it unconstitutional to have invocations at graduation. So had the Supreme Court voted in favor of the school district, they would have been going against the Supreme Court decision that was upheld in Lee versus Wiseman. So they really used this case as the backbone and kind of the platform going forward of saying that this wasn't private speech, that it was unconstitutional, and that it was violating students' rights. Another really big thing that has to do with this case is that there was tremendous social pressure involved, and the court felt that that in itself added on to why it was unconstitutional, because students feel social pressure to go to these games or to not go to these games, and people like the cheerleaders, the fans, the staff, even the players were being forced whether or not to attend a school-sponsored event because there could have potentially been something that was religiously offensive to them. So the Supreme Court did decide that it was unconstitutional. They used the Lee versus Wiseman case to help support their decision because it wasn't private speech. So the policy was removed, and the prayer election that they had was banned, and there was no more school prayer allowed at these football games.